Dear brothers and sisters, I welcome you all to see the lack of appropriate legislation for genocide in India. Content for this video I given in the description. You can go through and study. Indian domestic law shows that there are no comparable provision for the prosecution of any mass crime, least of all genocide. Indian Penal Code provisions relating to the rioting, unlawful assembly and promoting enmity between different groups do not embody the basic elements of the crimes of genocide, which is against the collectivity or a group with a specific intent to cause its destruction. There is no provision in the Indian Penal Code that criminalizing killing or causing serious bodily or mental harm to individuals of a particular national, ethnic, racial or religious groups with the intent to destroy such a community in whole or in part. In other words, mass murder by the specifically targeting individuals of a particular group, which is the essence of the crime of genocide, it is not recognized as a crime beyond murder, simpliciter and other associated crimes against the human body. Indian law remains unable to conceptualize the mass crime within the inadequate framework of the Indian Penal Code, which is better suited to deal with individual crimes. Taken a step further, Indian law refuses to entertain the possibility of the state being accountable for offences it might commit. This is made explicit in section 197 of the Criminal Procedural Code, which lays down that the sanction of the government, both central and state, is necessarily before the prosecution of a public servant for acts committed in the discharge of his duty. Indian law entrenches impunity in law for its official for offences it might commit against its citizen. The need for sanction to prosecute public servants as stipulated by section 197 of the Code of Criminal Procedure is a definite roadblock to the effective realization of the application under Article 4th of the Genocide Convention Act, which requires the punishment of guilty persons irrespective of their official positions. As is well known, the section 197 has been used as a shield to protect guilty public servants from prosecution. In the trial of Rwanda genocide, the tribunal said that the systematic rape of Tutsi women was not just a sexual crime. It was meant to terrorize the whole Tutsi community in order to eliminate them. Hence, rape here was recognized as an act of genocide. In India, the recent cases of actioning of Muslim women on social media handles and through apps points to the use of sexual violence as a genocide tool. An important point to note here is that only vocal women of one particular community are targeted. In all instances, outspoken women from mostly Muslim backgrounds have been listed and their pictures morphed. Both Sulli and Pulli are derogatory slangs used to refer to women belonging to this Muslim community. This establishes that these acts are done with the intent of terrorizing them and their community as a whole. These events must not be seen in isolation, as all these events point to one larger goal. At a Hindu Mahapanchayat last year, among other hateful invectives, calls were made to kidnap Muslim women. In India, there is a failure to understand sexual violence as a part of the mass crime, thereby being complicit in guiding violence against women in Indian Penal Code and Criminal Penal Code laws. India's denial of the 1984 program as genocide is problematic given the non-existence of prescribed domestic standards to test such a claim. The 1984 anti-Sikh violence, as in most other cases of genocide, involved a mass murder of individuals belonging to an identifiable protected group. Claims of the 1984 pogroms being a genocide on certain occasions and a denial of the characterization on certain other occasions reflect the casual and non-serious approach of the Indian political class to the human tragedy accompanying mass crimes in India. This problem is aggravated by the absence of a law laying down the contours of the offences, like its essential elements, requirements and punishments. It can clearly be seen that in the absence of any relevant laws specifically for the prosecution of individuals committing genocide, the investigations under the Indian Penal Code and the Criminal Penal Code does not seem to be giving due justice to the victims. The incidents of mass crimes don't seem to be being investigated properly because of poor and insignificant laws associated with mass crimes. So India should make prevention and punishment of the crime of genocide act as early as possible. Bible talks about lack of legislation for communal violence and genocide crimes in India. In Psalms chapter 12 verse 4, they say, "Through our tongues we have power, our lips are our own, who can be our masters?" In Genesis chapter 34 verse 30, "And it shall come to pass when those all have the dominion, you will break away from his control." Amen.